Thank you. Please be seated. Court is now in session. Calling case number 251-403-576, State of Utah versus Tyler James Robinson. Counsel, please enter your appearances.
State.
Good morning.
Good morning, Your Honor. Kathy Nestor, Michael Bird, Richard Novak, and Stacy Visser for Mr. Robinson, who is present.
Good morning. Good morning to Mr. Robinson. All right. Before addressing today's business, the court takes up a couple of preliminary matters. First, with respect to courtroom protocol to maintain security and decorum, any individual who exits the courtroom during proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. In addition, the microphones at counsel table are turned off as a further precaution. And when making argument, if that occurs, I ask you to approach the lectern when you do so. Second, the court will address the camera operator and still photographer. And would those individuals please come forward to the lectern. Thank you. If you could state your full name, both of you. Good morning. So the purpose is to ensure clarity regarding the expectations governing today's proceedings. And could you, have you reviewed the court's standing decorum order dated February 24th, 2026? Yes. All right. Do you understand the requirements set forth in that order as they apply to your activities today? Do you require any additional time to review the order or to adjust equipment to ensure compliance? And do you anticipate any difficulty complying with the order? All right, I appreciate your cooperation. Thank you. Turning next to defense motion to stay pending interlocutory review, and the court will issue its ruling on this matter. Before the court is defendant's motion to stay pending interlocutory review. Defendant seeks to stay all further proceedings in this capital case, specifically the preliminary hearing scheduled for the week of July 6, 2026, pending the Utah Supreme Court's disposition of his petition for permission to appeal from an interlocutory order. The state filed an objection to the motion, and defendant subsequently filed a reply. Having considered the parties' briefings, the factual record, and the relevant authorities, the court issues the following ruling in order. Defendant is charged with the aggravated murder of Charlie Kirk, a capital felony offense. The media interest in this case is extraordinary within the state of Utah. Due to this, photographers, TV cameras, and microphones from the courtroom seeking a categorical ban on electronic media coverage during all proceedings. On May 8, 2026, this court issued its camera ruling denying defendant's request for a blanket ban and concluding that under Utah Rule of Judicial Administration 4-401.01, requests for electronic media coverage must be evaluated on a proceeding-by-proceeding basis rather than through a categorical prohibition. The court also established procedures designed to provide advance notice of media requests and an opportunity for the parties to be heard before any such request is decided. Subsequently, on May 29, 2026, defendant filed a petition for permission to appeal from an interlocutory order with the Utah Supreme Court challenging the camera ruling on state and federal constitutional grounds. On June 6, 2026, the Supreme Court issued an order requesting that the state and various media organizations file responses to defendant's petition within 14 days. Additionally, on June 1, 2026, this court denied defendant's motion to close portions of the upcoming preliminary hearing and seal exhibits, concluding that defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure, particularly where much of the information at issue was already publicly available. The parties dispute the precise legal standard governing a motion to stay pending interlocutory review. Defendant argues that the granting of the stay lies within the inherent and discretionary powers of the court, varying according to the requirements of each individual case. In addition, defense argues Rule 8 of the Utah Rules of Appellate Procedure, which requires him to request a stay in the trial court before seeking a stay from the Utah Supreme Court. Conversely, the state argues that under Rule 8C2 of the Utah Rule of Appellate Procedure, a movement must demonstrate A, a likelihood of prevailing on the appeal, B, a likelihood of irreparable harm to the movement outweighing the harm to any other party, and C, that the stay is not adverse to the public interest. Defendant contends the factors contained in Rule 8C govern the waiver of a bond or security requirement and do not establish the substantive standard for granting a stay itself. The court concludes that regardless of whether the motion is analyzed under the discretionary authority recognized in Lewis or under the factors identified in Rule 8C, the result is the same because defendant has not established either a sufficient concrete threat of irreparable harm or that the balance of equities favor a stay. Defendant argues that proceeding with the July preliminary hearing while his petition remains pending will cause irreparable harm to his constitutional rights to a fair and impartial jury. Specifically, defendant relies upon the expert opinion of Dr. Christine Ruva, who opines that electronic media coverage of the preliminary hearing may expose prospective jurors to inadmissible hearsay evidence and create unconscious bias. Defendant further relies on Shepard, James, and Hollingsworth, arguing that once the proceeding is publicly broadcast, any resulting prejudice cannot be undone. The court takes defendant's concerns seriously. The potential impact of extensive media coverage in a capital case is neither hypothetical nor trivial. The court further recognizes, unlike many forms of pretrial prejudice, widespread dissemination of information through modern electronic media may be difficult or impossible to fully reverse once it occurs. The question presently before the court, however, is whether the record establishes a sufficient concrete and imminent risk of prejudice to justify staying all proceedings while interlocutory review remains pending. The court concludes that the asserted threat of prejudice has not yet been shown on the present record to be sufficiently concrete to justify the extraordinary relief requested. The court does not minimize defendant's concerns regarding publicity in a case of this magnitude. Indeed, the court has previously recognized that media attention surrounding these proceedings is extraordinary, and that dissemination of preliminary hearing evidence presents challenges not ordinarily encountered in most criminal cases. Nevertheless, extensive publicity does not, standing alone, establish that an impartial jury cannot ultimately be selected. Courts have long addressed highly publicized prosecutions through established procedural safeguards, including expanded jury pools, detailed jury questionnaires, individualized voir dire, venue-related remedies where appropriate, and careful judicial supervision of the jury selection process. As the United States Supreme Court observed in Nebraska Press Association versus Stewart, pretrial publicity does not inevitably lead to an unfair trial, and predictions regarding its ultimate impact are often uncertain. Likewise, prominence does not necessarily produce prejudice, and jury impartiality does not require ignorance. In its June 1st, 2026 order denying closure, this court concluded that defendant had not demonstrated a realistic likelihood of prejudice sufficient to justify closure of the portions of the preliminary hearing. Should concerns regarding prejudice arise as the case progresses, this court retains broad authority to employ traditional safeguards to protect defendants' constitutional rights, including expanded veneer procedures, comprehensive jury questionnaires, individualized voir dire, changes of venue when warranted, and other remedies authorized by law. Moreover, no media organization has yet filed a request for electronic media coverage of the July preliminary hearing, and the court has not been called upon to determine whether such coverage will be permitted. Accordingly, the asserted injury presently depends upon future events that have not yet occurred, including whether any request for electronic media coverage will be filed, and if so, how the court will rule on such a request. At this juncture, the court cannot assess those contingencies with sufficient certainty to conclude that a stay is necessary. The court recognizes defendants' arguments that the alleged injuries arise not merely from the possibility of future media requests, but from the operation of the framework established in the court's May 8, 2026 order while appellate review remains pending. The court has carefully considered that concern. However, because any request for electronic media coverage remains subject to case-specific review, and because no determination regarding coverage of the preliminary hearing has yet been made, the court concludes that the asserted injury remains contingent rather than immediate. On the present record, the possibility of future electronic media coverage does not establish a sufficient concrete basis for staying all proceedings pending interlocutory review. The court's denial of a stay should not be understood as a determination that the defendant's concerns lack merit. Rather, the court concludes only that the current record does not establish that such concerns have matured into a concrete and immediate threat request requiring present intervention. Given the procedural safeguards available to ensure the selection of impartial jury, defendant has not established irreparable harm warranting a stay at this time. In balancing the equities, the court must also consider harm that a stay would impose upon other interested parties. The state argues that delay may impair the orderly presentation of evidence, increase risk of faded memories, and affect witness availability. The court finds those concerns legitimate and entitled to consideration. Additionally, the victim representative has formally asserted her right to a speedy disposition of this matter. Under the Utah Constitution and Utah Code, victims possess important rights to proceedings free from unreasonable delay, and courts are obligated to consider those interests when exercising discretion in criminal cases. The court acknowledges defendant argument concerning victims' rights and defendants' constitutional protections. However, because the court has concluded that the defendant has not demonstrated a sufficiently concrete threat to those protections on the present record, the court finds that interests favoring the continued progression of the case weigh against imposing a stay. The court continues to adhere to the reasoning set forth in its May 8, 2026 camera ruling and its interpretation of Utah Rule of Judicial Administration 4-401.01. At the same time, the court recognizes that reasonable jurists may disagree regarding the proper application of that rule in a case receiving this degree of public attention. The court further recognizes that the Supreme Court's request for responses indicates that defendant's petition presents substantial issues warranting careful appellate consideration. The court does not regard the Supreme Court's request as a routine procedure event and acknowledges that the issues raised are of sufficient significance to merit serious review. The court expresses no opinion regarding whether the interlocutory review ultimately should be granted. The existence of a substantial legal question, however, remains distinct from the separate question presently before this court, whether the defendant has demonstrated that a stay is presently necessary pending further review. The court remains persuaded that the procedures established in its May 8, 2026 order are consistent with Rule 4-401.01 Any future requests for electronic media coverage will be evaluated on the specific record then before the court, after affording the parties a full opportunity to be heard pursuant to the procedures previously established. Finally, the court concludes that the public interest presently favors allowing this matter to proceed in the ordinary course. The public possesses a substantial interest in the fair, orderly, and timely administration of criminal justice. The court further recognizes that public confidence in the judicial process depends both upon transparency and upon the preservation of constitutional trial rights. The court remains committed to safeguarding both interests throughout these proceedings, staying the preliminary hearing while the Supreme Court considers whether to grant discretionary interlocutory review would result in additional delay despite the absence of a presently demonstrated need for such relief. The court recognizes the seriousness of defendants' concerns and the significance of the issues presented before the Supreme Court. The court further recognizes that concerns regarding pretrial publicity and electronic media coverage implicate important constitutional values and warrant careful judicial review. Nevertheless, the potential prejudice identified by defendant has not yet matured into a concrete and immediate threat requiring intervention in the form of a stay. Established procedural safeguards remain available to protect defendants' right to a fair trial should further circumstances warrant their use. By contrast, the stay would impose an immediate and concrete burden upon continued progression of this case, including the interests of the state, witnesses, and victim representative, as well as the broader public interest in the timely administration of justice. Nothing in this order should be construed as foreclosing defendant from renewing an appropriate request for relief should further developments materially alter the circumstances presently before the court. Should future developments demonstrate a material difference of level of publicity, media exposure, jury contamination risks, or other circumstances affecting defendants' fair trial rights, the court will not hesitate to revisit appropriate protective measures. Likewise, nothing in this order predetermines how the court will rule on any future requests for electronic media coverage of a particular proceeding. Accordingly, the defendant has not established that a stay of the proceedings is presently necessary or appropriate. It is hereby ordered that the defendant's motion to stay pending interlocutory review is respectfully denied. And that concludes the order of the court as it relates to the stay. Mr. Novak.
Thank you, Your Honor. On the same subject matter, and with respect to the timing laid out in the court's May 8th, 2026 order, we have a concern on behalf of Mr. Robinson that for the court to, well, let me just back up. There has been a request for electronic media coverage in every single hearing in this case. So I think it's fair for the court and the parties to anticipate that there will be a timely, under the May 8th ruling, request for electronic media coverage for the preliminary hearing. Mm-hmm. The court set up what I'll call a briefing schedule for how the parties respond to that request for electronic media coverage, but it appears to us that the court wouldn't rule on the request for electronic media, any request to prohibit or limit electronic media coverage until the morning of the preliminary hearing. And I think that creates some problems, at least for Mr. Robinson, because if the court were to disagree with the relief Mr. Robinson seeks, we have no opportunity to seek review of Your Honor's order. And the court just laid out its acknowledgement that there are serious constitutional issues which other jurists may disagree with vis-a-vis the court's conclusions. So the request is that the court modify in some way the timing of that litigation so that the parties and the media can have and their counsel can have a ruling sufficiently before the first day of the preliminary hearing so that if some judicial review is going to be sought, it's not happening after the preliminary hearing has already begun.
No, and I appreciate that, Mr. Novak. I note your concerns, and it is for that very reason that the court modified what was the procedure before, which, and please correct me if I'm wrong, I'm kind of going off my memory, but the media was required under the rules to give, was it 1 day notice before the hearing?
It was something like that. So, the notice.
Hold on, I want to finish. Sorry,
yeah.
But I appreciate you. And so the court expanded that to allow briefing, where under the current rules, as they're stated now, it wouldn't even allow for briefing. It would create a greater issue that you're proposing, because you wouldn't even be able to file a motion, no response and no reply. The intent of the court was to give the parties sufficient notice or more notice than the rule currently allows, to allow briefing, to allow that to be presented, and for the court to consider that as opposed to making a snap decision the morning of the prelim. So the court's coming in with more information than simply the request for media coverage being filed the day before, and then the parties trying to come up with an argument, and the court trying to make that decision on the day of trial. And so that's the difference, and the court anticipated that concern and wanted to give the parties that ability to articulate their concerns and allow the court sufficient time to consider those arguments and weigh those arguments against the constitutional rights of all parties and render the best decision it can.
So I acknowledge all of that. I agree with all of that. I appreciate all of that. What I'm referring to is Mr. Robinson's, or, depending upon how the court rules, the state or the media's opportunity to seek interlocutory review if, as Your Honor states, it is true that what has to be shown is the harm under facts that relate specifically to the preliminary hearing. Okay, so the court has denied what I'll call a more general blanket request to preclude electronic media coverage. The court has said it's going to take it up on a hearing-by-hearing basis. And the court has also said that reasonable jurists may disagree with the court's substantive conclusions and the court's ruling on our request for a stay. And what I'm suggesting respectfully is we may be in the exact same place, one of the parties may be in the exact same place in the moments before the preliminary hearing, at least presently, is scheduled to begin on July 6th. So my question is, can we get a ruling from the court sufficiently before July 6th so that if some party seeks a stay and interlocutory review, we're not doing that on July 6th or July 7th or July 8th, because by that point in time, it's too late. So we could have a ruling by WebEx. We could have argument and ruling by WebEx. I totally respect that the court has a very busy calendar, and I also understand that the preliminary hearing is starting 2 days after the 4th of July, which this year is a big deal. So what I'm trying to just do is plan ahead and think about whether the schedule that the court set, which we agree makes a significant difference in our ability to litigate before Your Honor the issue, a way to resolve this so that we also have the ability to seek review before it's too late.
No, and
I'm literally talking about the last few days of the week before. That's, I think, what we're talking about.
And I appreciate that. And where I'm coming from is the court cannot issue anticipatory rulings. I can't go off hypotheticals. And I understand what you're saying. I recognize that media requests have been filed. But I can't issue a hypothetical ruling. It has to be squarely before me. And I respect what you're saying, but I imagine that you're probably preparing. Well, I'm not going to assume. It's not appropriate. But perhaps you are already preparing those motions in anticipation of such media requests being filed, and in addition to anything else that you may consider, and rightfully so. And so and there's also sufficient time between now, given the ruling that the stay is not being granted, knowing that the preliminary hearing is moving forward, that it appears that there may be sufficient time for the parties to prepare accordingly. Again, the court needs to wait until it's squarely, that media request is been filed, whether the parties file motions. It's possible that the parties may or may not. I can't anticipate that, but I need to wait until it's actually before me, as opposed to trying to read the tea leaves and guess.
I'm not asking the court for tea leaves, so maybe I've been obtuse. What I'm saying is that the court's order currently provides that it will issue its ruling on any objection to an EMC request the morning of the hearing. And that's the problem. I'm not asking the court to issue a ruling now. I'm not asking the court to assume there will be an EMC request. I can tell the court that if there is an EMC request, we will file an objection to that, which shouldn't be a surprise. And so what I'm just saying is, for the orderly administration of justice, and in light of the possible judicial divergence of opinion that Your Honor has acknowledged, we are asking the court to build into the schedule that it has set for any objections to any EMC request that may be filed, a period of time before the subject hearing at which the parties would receive a ruling. And if I suggested in my statements that we are actually asking the court to assume that there's an EMC request and that we would oppose it and that we're asking for a ruling now, we're not. We think there should be a request and there should be briefing. We're just asking that the court build into the schedule a ruling moment that allows us, if necessary, or some other party, if necessary, to seek review.
Thank you, Mr. Novak. And the other kind of X factor is how quickly the parties respond. If a motion is filed, and let's say an EMC comes out on day 1, and a motion is filed on day 2, and then the state files on day 3, there may be more time. And so one of the variables is how quickly the parties respond, which the court doesn't control. And so that's a factor that may allow the court additional time to accomplish that. And this court has tried to be very diligent in in expediting addressing motions and not letting them sit too long, because I know it's important to defense and to the prosecution and to all parties. And so the court is cognizant of that and will respect that and issue its rulings or its analysis as quickly as possible to afford you that ability.
So the court did set deadlines for briefing, and what I will do when there's an appropriate break in today's proceedings is we'll speak with counsel for the state about whether we can agree to modify that briefing schedule that the court set so that the EMC request and the parties' responses to it can be submitted to Your Honor more in advance, further in advance of July 6th than the current schedule allows. And then if we can agree on something, or if we can't, we will let the court know that. And I'm still going to ask the court to look at its calendar and suggest a hearing date, if necessary, on what we, I think, can fairly anticipate will transpire. Again, because the media has requested that their cameras be present at every hearing, and it would seem to me that they would not miss the opportunity, from their point of view, to broadcast the preliminary hearing.
Thank you, Mr. Novak. I appreciate you addressing those or bringing those concerns
So we'll bring that back to the court at the appropriate time today.
Thank you, Mr. Novak. Does the state wish to be heard on this issue?
Yes, thank you, Your Honor. Christopher Ballard on behalf of the state. I'd just like to point out that even assuming that there's a request for electronic media coverage, which the state fully assumes there will be, and that the court grants that request, the equities as far as whether or not to stay things to allow the defendant to then appeal that ruling, that's really not going to change. The circumstances that the court's already articulated in its order today, those equities really aren't going to change between now and the preliminary hearing. And the appropriate procedure for reviewing a court's orders on electronic media coverage is not to pause the trial proceedings and allow defendant to seek interlocutory review of every order. The defendant can certainly do that. He has the right to do that, but that's not the appropriate remedy. I just remind the court of the United States Supreme Court statement in Chandler versus Florida, where it said that the appropriate safeguard against potential prejudice from pretrial publicity is the right to demonstrate that the coverage compromised the ability of the particular jury that heard the case to adjudicate it fairly. So defendant's claiming he doesn't have a remedy. He does have a remedy, and the remedy is to challenge the court's media order at the plenary appeal after this case is complete. Thank you.
Thank you, Mr. Ballard. All right, anything further before we move on?
Yes. We can take this up whenever the court wishes to take it up. And in addition to the two substantive issues which the court calendared for today, which is the hearing on the court's issuance of an order to show cause re contempt and the argument of a pending and fully briefed motion concerning the constitutionality of hearsay evidence in a preliminary hearing, Mr. Robinson filed with a motion to classify a document which I'll just describe as having privately been filed, seeking certification for an out-of-state subpoena for the preliminary hearing. And the court is nodding, so I understand that the court is aware of it.
I've reviewed that.
Okay. So again, because of timing issues, we would like at some point today to receive from the court a briefing schedule on that, because out-of-state enforcement of a subpoena, if the court certifies it, is obviously something that takes a little bit of time. And in light of the court's denial of the stay, for the moment, we have to assume that if that certification is granted at our request, and by the way, we've served counsel for the witness with that request as well, okay. That we need time for an out-of-state counsel to appear in the appropriate jurisdiction and get an order enforcing that. I can't imagine that if the court granted the certification that there's going to be an issue about serving the witness, but we don't have a valid subpoena unless Your Honor certifies the application and then a court in the appropriate jurisdiction enforces.
Thank you. And I note that that was filed last night around 8:04 p.m.
It was.
What you're referring to?
Yes, that's exactly what I'm referring to.
All right. Thank you. The court will take that under advisement and figure out. The court will address that at some point today. Thank you for bringing it to the court's attention, Mr. Novak. All right. Let's continue on. Counsel for the state, could you provide a brief status update regarding a discovery?
Yes, discovery continues to roll in and be processed and provided to the defense on Tuesday, June 9th, 2026. We sent 11 additional items to the defense.
Oh, Mr. McBride, if you wouldn't mind starting over, and yeah, that's where the live mic is.
Understood. Thank you. Brian McBride for the state. As of June 9th, 2026, we sent 11 additional items to the defense. 10 of these items were notebooks that were obtained and requested from the defense in a discovery review. One is an 1102 statement that was provided in preparation for the preliminary hearing. This is everything, essentially everything we have from the investigative agencies to date. The percentage provided to the defense is approximately 100%.
Thank you, Mr. McBride. All right. Turning to the defense motion for an order to show cause for alleged contempt of court. This is set for an evidentiary hearing and argument. The court has reviewed the briefing submitted, and the each side will be afforded 90 minutes to present evidence and argument. If defense intends to reserve time for rebuttal, counsel should plan accordingly. Following argument by defense or a presentation of evidence, the court will take a 10-minute recess and then turn to the state. Because this is the defendant's motion, the defense will proceed first. Mr. Novak.
Thank you, Your Honor. Mr. Robinson would first ask the court to direct Mr. Ballard to take the witness stand.
All right, Mr. Ballard, if you wouldn't mind coming forward and being sworn in.
Do you solemnly swear that the testimony you shall give in the case outstanding before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Ballard, if you wouldn't mind getting situated to your left are water bottles, and after you're seated, if you wouldn't mind pulling that microphone close to you to ensure that the record picks up your testimony. Thank you. Mr. Novak, it's your witness.
Thank you, Your Honor. Mr. Ballard, what are your formal titles within the Utah County Attorney's Office?
I am the general counsel and public information officer.
Okay. You're testifying here today because the court has issued an order to show cause regarding contempt of a court order. And so there's a white notebook that I placed up there. Do you have that, sir?
I do have it. Yeah.
All right. Why don't we first turn in that notebook, and Your Honor should have one as well.
I don't.
I passed it up to
there
the
it
clerk.
is. Thank you. I now have it, Mr. Novak.
All right. Thank you, Your Honor. Mr. Ballard, why don't you turn to Exhibit 8? And just let me know when you've seen it and had a chance to look at it.
I've seen it. Thank you.
Okay. Is this the order entered by this court on September 16th of 2025 entitled Protection Order, Ray Pretrial and Trial Publicity?
It appears to be yes.
All right. And, Your Honor, I understand that a court exhibit doesn't technically need to be received into evidence. Of course, the record is what it is. It could take judicial notice of it, but I just think for completeness of the record, would the court mind if we ask the court to receive Exhibit 8 into evidence?
To the state, any objection? No objection. All right, and if you wouldn't mind, so if, as I turn to both parties, because your microphones are turned off, if you wouldn't just mind projecting a little bit more so the record picks it up.
No objection.
Thank you, Mr. McBride. All right, so is this going to be defense exhibit number?
8.
All right.
They're pre-marked, so we'll just stick.
Just sticking with those numbers.
I think it's easier for the record than changing the order. And
I appreciate that.
All right, thank you.
Defense exhibit 8 is admitted and may be published.
I think. And Mr. Ballard, did you read this order either the day it was entered or shortly thereafter?
Yes.
So you were aware of it shortly after it was entered, correct?
Yes.
All right. Why don't we also turn now to Exhibit 9? And same question. Please let me know after you've had a chance to look it over.
I've looked at it.
All right. And is this an order clarifying, let me be more clear, an order of this court dated December 15th, 2025, clarifying at the state's request the order that is now Exhibit 8?
Yes.
And could the court receive into evidence, please, Exhibit 9?
No objection.
Thank you, Mr. McBride. With no objection being made, this is entered into evidence as Defense Exhibit 9 and may be published.
And, Mr. Ballard, with respect to these two orders, would you agree with me that subject to the clarification, these orders track Supreme Court Rule of Professional Practice 3-3.6.
Yes, they track that rule. They require both parties to abide by that rule.
And would you agree with me that you are a prosecutor also subject to Rule 3-3.8?
Yes,
And that everybody in your office is a prosecutor under the, within the meaning of 3-3.8?
the attorneys in our office, yes.
The attorneys in your office, correct. And again, Your Honor, these are rules of professional practice, but I am going to ask the court to receive into evidence for purposes of this hearing both Exhibit 10, which is a true and correct copy of Rule 3-3.6 with its comments, and Exhibit 11, which is Rule 3-3.8 with its comments.
No objection.
With no objection from the state, defense exhibits 10 and 11 are admitted and may be published.
And Mr. Ballard, were you familiar with these rules prior to the court issuing the orders, which have now been received as Exhibits 8 and 9?
Yes,
All right. So would you agree with me that you knew what was required under the court's pretrial publicity orders?
yes.
Did you have any inability to comply with those orders?
No,
All right, Mr. Ballard, would you look at Exhibit 2, please? And again, please let me know when you've had a chance to look it over and familiarize yourself with it.
I've looked at it.
And do you recognize this to be an email that you sent to counsel for Mr. Robinson on December 22nd, 2025?
Yes,
And the subject of this email was your notice of intent, the state's notice of intent to conduct non-destructive testing, correct?
correct.
All right. Your Honor, before I go any further, could the court please receive into evidence Exhibit 2?
Mr. McBride?
If I can have just a moment.
All right.
No objection, but as it goes to publication, this includes email addresses. If this is made public, those email addresses should be redacted.
All right. Mr. Novak?
We will provide the court with a redacted version of the exhibit that masks all of the emails that are email addresses that are listed at the top of the exhibit.
All right. Based off the state's not making an objection, but requesting a redacted version with removing emails, Defense Exhibit 2 is admitted.
Thank you. So, Mr. Ballard, just so the court, because the court has probably never seen this email, I want to go over with you the context and the purpose of this email. The state had determined back in this time period, which is December of 25, that it wanted forensic examiners to do some further testing of a bullet, jacket, fragment, and lead fragments, correct?
Yes,
All right. And under a prior order of the court, it was the state's responsibility to notify Mr. Robinson's defense counsel of any testing, which may, let's just say, change the nature of the physical evidence.
Correct.
All right. And so what you were doing in late December of 25 was notifying us privately that the state intended to conduct some additional testing, correct?
Correct.
And you state in this email that the reason why you don't want to publicly file this notice of intent to conduct further testing, at least at that time, was because of a comment to Rule 3.6. That's the same Rule 3.6 that the court has received into evidence as Exhibit 10, correct?
Correct.
And what you say is that the comment to Rule 3.6 of the Utah Rule of Professional Responsibility lists, quote, the performance or results of any examination or test, close quote, and, open quote, the identity or nature of physical evidence expected to be presented, close quote, as subjects to avoid in public comments. Those were your words, right?
Correct.
And then I would also now like to ask you to look at Exhibit 6. And I know I will sound repetitious, but please look it over and let us know when you've reviewed it.
I've reviewed it.
And is this an email that you sent to one member of Mr. Robinson's defense team, and then it appears that it was copied to other attorneys in your office?
Correct.
Your Honor, before I go into the details of it, could the court please receive it into evidence as Exhibit 6 with the same proviso, which is that we will provide the court at a later time with a redacted version that masks the email addresses?
No objection, but the email addresses are not included here, so.
Well, there is one at the very bottom of the signature for Mr. Ballard.
Thank you. Excuse me.
No worries.
And Ms. Visser's below that as well, Your Honor.
All right.
But I think we're all on the same page about what to do.
It sounds like it. So that Defense Exhibit 6 is admitted with the following redactions being noted. Thank you.
Okay, so Mr. Ballard, in this email, you're informing us that the state no longer believes that filings concerning this additional testing from the state's point of view should remain private, correct?
I don't recall exactly the question that Ms. Visser had posed to me and that I was responding to, but the general, the email speaks for itself.
Okay, so the email says in the top paragraph, but now that the court is involved, we do not believe that it is necessary to keep court filings private or even file redacted versions on this issue.
That's correct.
And this issue refers to whether the state can proceed with the further testing and Mr. Robinson's objections to the way in which the FBI wanted to do the testing, correct?
Correct.
I mean, basically, okay, so that's that dispute. What you say in the second paragraph is the ethical rules on pretrial publicity apply only to extrajudicial statements, right?
Correct.
And so what you're saying is that if we talk about physical evidence testing that has been done, testing will be done, what the results of the testing are. If we talk about those, we meaning counsel, who are subject to the rules and the court's orders in filings, we're consistent with Rule 3.6, right?
Correct.
But if we talk about them extrajudicially, that's prohibited under 3.6.
Correct. Unless we're talking about public records. Unless we're talking about a filing.
I'm not sure what you are modifying with the word unless, and I'm not trying to be difficult. Are you saying that you can make extrajudicial statements about anything you want that's in a public filing without violating Rule 3.6? Is that what you mean?
What I mean is exactly what the rule allows, and that says that a lawyer may state information contained in a public record.
So if you file something that relates to issues that the rule says should not be commented upon extrajudicially, you're saying that that opens the door. The mere filing of something opens the door to making any extrajudicial statement that you want about that subject matter?
No, that's not what I'm trying to, no.
Okay, so why don't we let Mr. McBride ask you about that interpretation, because I'm going to move on to my next question. Why don't you turn, please, to Exhibit 1. And this is not an email from you, but it is one that you are copied on. It's actually a series, a couple of emails and a letter all together in Exhibit 1. Do you see all that?
Yes.
Okay. So first, let me ask you if you are familiar with the first 2 pages of Exhibit 1, which are string of emails that basically start with Mr. McBride writing to, I mean, the email addresses are redacted. This is how we received it. But let's just say writing to many people who are in government or in law enforcement. Would you agree with that?
Yes.
All right. And you're copied on that email as well, right?
Yes.
All right. And then if you go to the 3rd page of this exhibit, and I should back up, Mr. McBride's original email to the law enforcement and government individuals I was referring to was September 15th of 2025, right?
Correct.
Which is actually the day before the court entered its first publicity order, correct?
Correct.
All right. So if we go to the 3rd page of this exhibit, this is an email from you also a couple days before the court entered its September 16th, 2025 order. And you're writing to, well, are you familiar with this email?
Yes.
All right. And now let me ask you to look at pages 4 and 5. Those are the last 2 pages, Your Honor, of this exhibit. This is a letter written by Mr. McBride. Do you see that?
Yes.
Dated also September 12th, 2025.
Yes.
You're familiar with that one as well?
Yes.
All right. So, Your Honor, I would ask the court to receive into evidence, subject to any redaction which Mr. McBride thinks is necessary of emails, although I think they've all been redacted before produced to us. All 5 pages we're asking the court to receive into evidence.
No objection.
All right. And this is State Defense Exhibit 1 with no objection from the state will be admitted.
Okay, so let's go back to page 1, Mr. Ballard. In his email, well, Mr. Ballard, you know generally who the people are who this email was sent to, right? The names behind the redactions?
Generally, yes.
Can I just refer to them as law enforcement partners?
Yes. I think that's accurate.
Some have email addresses that are local law enforcement agencies,
Correct.
Including Utah County, correct?
Correct.
Spanish Fork,
Yes.
Utah Valley University, not a law enforcement entity, of course, but they have a law enforcement department at UVU.
Correct.
All right. And at least a couple recipients are with the FBI, right?
Correct.
All right. And so in this email, Mr. McBride says at the bottom, quoting Rule 3.6, there are certain subjects that are more likely than not to have a material prejudice effect on a proceeding, particularly when they refer to a criminal matter that could result in incarceration. You see that?
Yes.
And then he says these subjects relate to, and then on the next page, I want to draw your attention to Roman numeral 3, the performance or results of any examination or test, or the refusal or failure of a person to submit to an examination or test, or the identity or nature of physical evidence expected to be presented. Do you see that?
Yes.
Do you agree with Mr. McBride's assessment that Rule 3.6 prohibits extrajudicial statements about that topic or those topics?
Yes, this email represents our efforts even before the court issued its order to recognize that we had obligations under Rule 3.6 and that we were careful to abide by those obligations.
You were careful to inform law enforcement partners in the email of their obligations, correct?
Yes.
And then item 4, Roman numeral 4, also on page 2 of the exhibit, says, as another example of subjects that are more likely than not to have material prejudicial effect on a proceeding, any opinion as to the guilt or innocence of a defendant or suspect in a criminal case or proceeding that could result in incarceration.
Yes.
All right, now if we could turn to page 3 of the exhibit. This is an email from you to what I will describe, unless you disagree with me, as law enforcement partners. Do you agree with that?
Yes.
Asking them to carefully review a letter, which is the following page, from Mr. McBride, dated September 12th.
That's correct.
And that letter also, the letter is addressed to all personnel likely to make media statements regarding the Charlie Kirk case.
That's correct.
And the letter says, just below that, the Utah County Attorney's Office has an ethical obligation to, quote, exercise reasonable care to prevent investigators, law enforcement personnel, close quote, and others from making public comments which, quote, have a substantial likelihood of materially prejudicing, close quote, the trial process. That's what Mr. McBride wrote in the letter that you forwarded to chiefs and others, correct?
Correct.
And Mr. McBride's letter also says that prosecutors have a special duty to ensure that law enforcement and other officials adhere to these rules, citing Rule 3.8E, correct?
That's correct.
All right. And then Mr. McBride identifies statements that should be avoided. Or I should say, yes, statements that should be avoided. Do you see that? Statements should avoid the following, colon?
Yes.
All right. And there are 4 bulleted items there, right?
Yes.
One of them, the third one, is opinions about the defendant's guilt or proper punishment. You agree with that?
Correct.
And do you agree with Mr. McBride that prosecutors have an ethical obligation to both avoid those themselves and to take special care to make sure that law enforcement personnel and others refrain from making such comments?
Yes.
And then the other statement that should be avoided are any other statements which could risk violating the defendant's right to a fair trial.
Correct.
And would you agree with me that the any other statements phrase by Mr. McBride in this letter would include the more specific prohibition on extrajudicial statements about the performance or results of examinations?
Yes.
Tests, yes? I'm sorry for interrupting you. The answer was yes.
Correct. Yes.
All right, I'm now going to turn your attention, please, to Exhibit 3. And I want you to take a moment to look at that. Tell me if you've seen it before, if you recognize it.
Yes. I recognize this.
Okay. Do you recognize this as an article published online by TMZ concerning this matter in which you are quoted?
Yes.
Okay. And my first question is, how is it that you came to be quoted? Well, actually, let me ask you this question. If you look on the second page of this exhibit, down toward the bottom, underneath the image of a black screen, the paragraph starts, Attorney Christopher Ballard tells us, comma, quote, and then there's a very lengthy, well, there's a few sentences in quotes. Do you see that?
Yes, I do.
Okay. Did you tell TMZ that?
Yes, I did.
All right. So my question is, was that over the telephone? Was it an email? Was it a face-to-face meeting? How is it that your quote was communicated to a representative, a media representative of TMZ?
It was a telephone conversation.
And did you only have one telephone conversation with TMZ?
Yes.
And how was it that the telephone conversation came to be set up?
After the defense filed its motion to continue the preliminary hearing, there was a statement in that motion that garnered quite a bit of media attention. I came to be aware of that media attention and the headlines that that statement had generated. And there were quite a few media inquiries to our office based on the statement in the defense's pleading and the media stories that that statement had generated. TMZ was one of the media entities that called our office. I received an email from someone else in the office, I can't remember who it was exactly, that said, I got a call. They received a voicemail from a reporter at TMZ. That employee in our office forwarded me that voicemail, and the voicemail just basically said, we have some questions about these issues that statement in the motion to continue had generated. And so I returned the phone call.
Before you returned the phone call, did you have any discussions in your office concerning whether there should be extrajudicial statements about the issues that you're describing?
Yes.
Okay, and did you discuss that with Mr. Gray before you returned that phone call?
Yes.
Did you discuss that with Mr. McBride before you returned that phone call?
No.
Did you discuss that with anybody other than Mr. Gray before you returned the phone call?
I know for certain that Mr. Gray and I discussed it. I have a vague memory that Mr. Grunander was involved at some point. But my memory is that Mr. Grunander was out of the office the day that all of this was breaking. And so he may have just been informed, brought into the loop after the fact by telephone. But I do recall that very early in the morning, I think it was of March 31st, because my memory is that the media story that launched all of this interest was posted, I think, late Monday afternoon, Mountain Time. And so by Tuesday morning, I was getting a lot of media inquiries. And I think Mr. Gray had also, my memory is that Mr. Gray received a phone call from Turning Point USA asking us if there was any merit to these media stories. And that's when Mr. Gray came into my office. My recollection, it was first thing Tuesday morning, and we discussed these media stories.
So Turning Point USA reached out to Mr. Gray, and Mr. Gray came to speak with you all about the same time that you received this forwarded voicemail from a TMZ reporter.
The voicemail from TMZ came later in the day.
Okay.
It was before noon, but it was a busy morning. There were a lot of media inquiries that were coming in that morning. And I know Mr. Gray and I met, I would say, first thing Tuesday morning to discuss this issue.
And you and Mr. Gray had a conversation which led to a decision to return the phone call and make a statement to TMZ?
I did not discuss every media inquiry with Mr. Gray. I think I just generally told him, he brought up the issue that there were concerning media reports out there, potentially prejudicial media reports. I confirmed to him that I was getting media inquiries, and we generally discussed whether it would be appropriate to respond to those.
Okay. So did Mr. Gray know that you were going to call TMZ back?
No, I didn't discuss with him every media inquiry. Our conversation was general. We reviewed the requirements of Rule 3.6. I don't recall that we actually pulled the rule and read it, but we were familiar with the rule, and it's what it prohibits and what it allows. And we believed that under, I think it's subsection C, and also under the court's order, which specifically references subsection C of the rule, that we could respond, that this was potentially prejudicial media stories that we did not generate, and that the rule allowed us to be able to respond to those.
Were you aware of any extrajudicial statements by the defense which generated that media coverage?
No, and nor does the rule require that.
Well, that's your legal interpretation of the rule, right?
No, that's not my legal interpretation.
I mean, you were here when Mr. McBride argued to this court at the last in-person hearing that as long as there's some negative coverage out there, regardless of the source, that the state has leave to make extrajudicial statements on the same subject matter.
I heard that argument, yes.
All right. And that's a legal argument, right?
Yes.
Okay. All right, so here's my question. The information in the TMZ article, which purports to quote you on the second page of Exhibit 3, is that an accurate quote? Is that what you said?
Yes, it's accurate. I don't know that it's word for what I said, but it accurately captures my statements to the reporter.
Okay.
Mr. Novak, and I don't mean to interrupt you, but are you intending to admit exhibit number 3?
Yes, now that Mr. Ballard has said it's an accurate recitation of what he told TMZ, I would now ask the court to receive it into evidence.
No objection.
All right.
So in that quote, you tell this TMZ reporter what your views are on bullet fragment analysis, correct?
I wouldn't characterize it as my views, although I guess you could say it's my understanding in general of how bullet fragment analysis works.
And you're also commenting on the contents of the results of the testing when you say the fragment didn't contain enough detail for the examiner to say one way or the other. That's you basically commenting on the content of the results of the examination as you understand them, correct?
What I'm commenting, if you look at the first word, I say generally, and generally when you have an inconclusive result, the reason that you get that inconclusive result is you do not have enough detail.
Okay, but now you're again testifying about your understanding of bullet fragment analysis, and I'm just asking you, if you told this reporter, it's an extrajudicial statement, what your views are on bullet fragment analysis, and you're reiterating the conclusions in a report about bullet fragment analysis.
Objection. The statement speaks for itself.
Would you like to respond to that objection, Mr. Novak?
Well, I don't think that the answer to the last question was responsive, so I was trying to go back to the question. I guess I could have moved the court to strike the answer as non-responsive.
I'll sustain the objection.
And then in the same quote, Mr. Ballard, after talking about bullet fragment analysis, you say, there's just not enough there to determine whether the bullet was fired by a particular firearm. That's you telling a reporter what you believe the forensic testimony in a proceeding will be.
No, what I'm referring to is generally the types of circumstances that could produce an inconclusive result.
Okay, but you say there's just not enough there to determine whether the bullet was fired by a particular firearm. You're referring to the fragments recovered, correct?
No. What I'm referring to, you got to read that in context with the first sentence.
I'd like to read it in context of the next sentence, which talks about the evidence, in your view, being sufficient to prove that Mr. Robinson committed the murder. You're commenting on the bullet, and then you're commenting on your opinion about the sufficiency of the evidence.
So here's how the quotes came about. The reporter first asked me about these, the media reports and the misleading statement in the defense's motion that the bullet that was recovered did not match the rifle. And I responded to that and said, generally, when you have an inconclusive result, it can be caused by these general types of circumstances. The reporter then asked me, well, do you still have a case? And focused specifically on whether the additional media reports out there that the supposed inability to match the bullet to the gun was a bombshell finding for our case, and that it completely undermined the foundation of our case. So that next statement was responding specifically to that question as to how does this specific, how do these specific reports and the representation in the defense's motion, how does that affect our ability to proceed with this case?
I'm going to move to strike portions of the statement which mischaracterize the defense pleading as misleading. This court has never made such a finding, and we had argument about Mr. McBride's interpretation of what is and is not exculpatory evidence. I think we all remember the court's comments on that. So I think without trying to parse it too much, I just ask the court to strike the portion of the statement which characterizes the defense pleading as misleading.
Mr. McBride.
I think the court can take this statement, the testimony, for the value it deems appropriate. Testimony is asking about Mr. Ballard's perceptions, and that's what he's testified about. The statement in defense counsel's pleading is a matter of public record, and what we're really talking about here are the reports that were generated from that statement. So I would ask the court not to strike it, but to take it for the value it sees appropriate.
All right. The court recognizes first that it has not made a finding that the defense's what defense presented in their motion was misleading, but also notes that this is the personal opinion of Mr. Ballard and makes that distinction. Thank you.
Thank you, Your Honor. So, Mr. Ballard, what you're saying is that you had, how long was the conversation with the TMZ reporter?
I think it was less than 10 minutes. It might have been just about 5 minutes.
And so the quote is a compilation of your statements over the course of the 5 or 10 minutes, right?
Right, and strictly in response to the questions that the reporter was asking me.
But you certainly had the discretion to not answer the questions, right?
Yes.
You could have said, I can't comment on specific evidence or what I think the quantum of evidence is, right? You could have said that.
Yes, and I didn't comment on any specific evidence.
Well, when you refer to the bullet, you're not talking about the bullet fragment removed from Mr. Kirk's body?
No, I'm talking about general circumstances that can produce an inconclusive result.
And isn't it fair, wouldn't you agree with me that one of the reasons why extrajudicial statements in many circumstances, and we assert in these, are prohibited is for exactly that reason, that reporters may, for either innocent or other reasons, take statements out of context or misconstrue things, and there's nothing you can do about it. Because once it's published, right?
Once something's published, it's published, yes.
Okay. Why don't we turn to Exhibit 4, please? And again, let me know when you've had an opportunity to look at that.
I've reviewed that. Thank you.
Okay. And did you have a separate conversation with a reporter from USA Today?
Yes, that was an email conversation.
So a reporter from USA Today wrote you an email and you responded?
Correct.
Did you preview your response with Mr. Gray?
No, again, we just had a general conversation about whether Rule 3.6 allowed us to respond to the prejudicial media stories that were circulating. And Mr. Gray and I agreed that it would be appropriate to respond under subsection C, and he left it to me to handle the responses.
Okay. So have you looked at the statements attributed to you in Exhibit 4?
Yes.
Are they accurate?
Yes.
Did the court receive into evidence Exhibit 4?
Mr. McBride?
No objection.
Right, with no objection, Defense Exhibit 4 is admitted.
Thank you, Your Honor. The third page, Mr. Ballard, of Exhibit 4, which is a total of 3 pages, so it's the last page. There's some paragraphs down at the bottom of the third page. On your copy, are they highlighted in sort of purple?
Yes.
And is the court's copy highlighted in purple?
It is.
All right. So, Mr. Ballard, you see the statement, I'm sorry, the paragraph, the second to last paragraph that says Ballard confirmed?
Yes.
Ballard confirmed the FBI and ATF are adding information to the initial reports, which prosecutors expect will include data supporting the initial conclusions. Do you see that?
Yes.
All right. Is that an accurate recitation or summary of what you said in your email?
Yes.
And so what you're telling this reporter is something that you understand the FBI and ATF will be doing in the future?
Yes.
And you're also telling this reporter what you think those reports will conclude?
Yes. This was in response to statements in the defense's motion to continue the preliminary hearing, where the defense represented that they did not have the supporting data, the underlying data that supported the initial conclusions. And the reporter asked me whether that had been produced, and I was responding that I anticipated that the FBI would produce the data that the defense was requesting.
Was that a matter of public record at that time, that the FBI and ATF were, quote, adding information to the initial reports?
I don't believe it was a matter of public record, other than the defense had requested additional information, and I was confirming that we were facilitating that request.
You were telling a reporter that we had made a discovery request and that you were complying with it.
Correct.
But you were characterizing what the FBI and ATF were doing with their examination reports, right?
No.
It says the FBI and ATF are adding information to the initial reports. That doesn't sound to me like producing additional discovery. That sounds like...
Objection. Counsel's testifying.
Counsel, would you like to respond?
I'll rephrase the question.
All right, so I'll sustain the objection. You may continue.
Thank you. Wouldn't you agree with me that what you are telling this reporter is that forensic examiners are changing their reports or adding information to their reports, as opposed to your office is obtaining additional background materials related to the testing?
No.
Let's go to Exhibit 5, please. Exhibit 5, are you familiar with that?
Yes, I've seen this article.
Did you have a conversation of any type with somebody associated with PolitiFact, P-O-L-I-T-I-F-A-C-T?
Yes, again, this was an email conversation with the reporter that's credited with the story in Exhibit 5.
And on page 2, about a third of the way down, there's a paragraph that starts with quotation marks, when the results of a bullet fragment. Do you see that?
Yes,
And that's a quote attributed to you, correct?
correct.
And then after identifying you, there's another quote attributed to you.
Yes,
And are those accurate reiterations of the email you sent?
yes.
Could this exhibit please be received into evidence as Defense Exhibit 5?
No objection.
Defense Exhibit 5 is admitted.
And in this second quote in this paragraph, your quote is saying there just aren't enough marks on the fragment to make a conclusion one way or the other, whether the bullet fragment was fired by the particular rifle.
That's what that quote says, but you have to read it in context with the previous sentence.
So it's your testimony that you're not referring to the rifle found by law enforcement at UVU, and you're not referring to the bullet fragment taken from the decedent's body? You're making a general statement about bullet fragment analysis?
Correct.
How did you end up appearing on Fox and Friends News and being interviewed?
Like many other media organizations, Claudia Cowan from Fox News emailed me, asked if I had any comment about the defense representation and its motion to continue and the media stories surrounding that, and I agreed to do a Zoom interview with Fox.
And did you discuss that with Mr. Gray before you did?
Not that again, I didn't discuss any of the specific media requests with Mr. Gray. We had the understanding that I should respond to the media requests as they came in.
How many media requests were there?
My memory is 8 or 9.
Okay, so you had a telephone call with TMZ, correct?
Yes.
And you had email communications with USA Today and PolitiFact,
Yes,
and you were asked to appear for a video interview by Fox and Friends.
yes.
Are there any other media entities who you communicated with directly in any of those ways? Parenthetically, because we're only aware of these 4.
Like I said, I think there were at least 8.
8 requests.
Yes, and I responded to all of those. I had a telephone conversation with a correspondent for NBC. I can't remember exactly all of the other news organizations that had contacted me.
Did you in any way collect the resulting news stories in which you are quoted?
No, I have some of them. I didn't make a search to find everywhere that I was quoted and collect those.
Okay, we would like, Your Honor, to show Mr. Ballard Exhibit 7, which is a video. And Ms. Visser is going to help us. Thank you. May we publish Exhibit 7?
Well, not before it's admitted.
Okay, so
if you want
we'll
to
show it to Mr.
lay
Ballard.
foundation, Sure.
We'll show it to Mr. Ballard, and maybe if the clerk could just show it to the witness before it's published. Mr. Ballard, can you look at the screen, actually?
It's going to take a few seconds. It's flickering while it syncs.
Thank you for your patience, Your Honor. Silent for a moment.
All right, looks like it's on the screens.
Okay, so we're going to actually, because of the court's ruling on publishing it, we're going to show it without the audio and ask Mr. Ballard if he recognizes it.
All right. Looks like our screens went off here, so.
Mr. Ballard, is your screen on?
Now
It's
it
on,
is.
Okay.
and it's playing.
Can Your Honor see it?
Yes, thank you.
Okay. All right, why don't we stop for a second? Mr. Ballard, is that you?
Yes, it is.
All right, do you recall doing this interview?
Yes.
Did you watch this interview after you participated in it?
I watched this story, yes.
Okay. Is this, as best as you can tell, an accurate digital copy of that broadcast where you were interviewed by Fox and Friends?
I haven't heard the audio, but I believe it is, based on what I've seen.
Okay, well, I'm going to ask the court to receive it into evidence, and if Mr. Ballard thinks that the audio is inconsistent with what he previously said, we'll withdraw the exhibit.
With that proviso, no objection.
All right. Defense Exhibit 7 is admitted and may be published.
Thank you. We'd now like to play it. And just so Your Honor knows, the entire thing is about 2 minutes and 12 seconds.
All right, thank you.
Rather than trying to cut it up, we'll just play the whole thing. Audio. Maybe.
Well,
Actually, and now we can publish it, so all the screens can be on, right?
it's on the screen. It's just the audio isn't coming through.
It says it's connected to the HDMI.
This is always the tricky part with technology.
Piece of evidence, the bullet that killed the
Do you want to
conservative
restart it now?
icon. In a new defense filing, attorneys for Tyler
Charlie Kirk are pushing to delay an upcoming trial hearing as new details come out surrounding the ballistics report.
Claudia Cowan joins us now with the latest. Good morning, Claudia.
Good morning, Lawrence and Brian, and also to you, Rachel. Nearly 7 months after Charlie Kirk was assassinated, lawyers for his accused killer are attempting to cast doubt on a critical piece of evidence, the bullet that killed the conservative icon. In a new defense filing, attorneys for Tyler Robinson say an ATF summary report, quote, was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. But prosecutors say that report is inconclusive and doesn't rule out a ballistics match to the rifle Robinson allegedly used or to any other firearm.
The examiners were not able to find enough detail on the fragments to be able to make a determination as to whether or not they can tie the bullet to the rifle.
Law enforcement sources tell Fox that when the bullet hit Kirk, it struck.
Mr. Ballard, was that your statement on Fox and Friends?
That was the statement that they chose to play. Yes.
Is that the statement you chose to make?
Yes.
And aren't you talking in that statement about the bullet fragment at issue in this case?
I prefaced that statement with the preface that I put on my other statements was that I'm not going to talk specifically about specific test results, but generally when there is a inconclusive result, these are the circumstances that could produce an inconclusive result.
So your testimony is that the statement that you just made to Fox and Friends is not referring to the bullet fragment in this case.
Right.
That's your testimony.
Right.
So obviously your office, Mr. Ballard, and apparently TPUSA were concerned with what I'm going to refer to as the media spin on the contents of the motion to continue, correct?
Can you
Your
rephrase
office
that?
was concerned, and TPUSA expressed concern about the way the media was, I'm just going to use the word spinning, I think we all know what that means, the contents of the motion to continue.
I can't speak for TPUSA because I wasn't privy to that phone call. But our office was concerned, yes, about the prejudicial media reports.
So my question is whether the goal of these interviews was to influence the reporting, or was it to change the what you were concerned was the public perception of the case?
The goal of these interviews was to respond to the specific media inquiries that were being generated by the misinformation that was circulating about the bullet testing.
But there's a reason why counsel who are subject to the rules we're talking about here, and especially prosecutors subject to these rules and the court orders, choose to engage in extrajudicial statements. I understand your position is it's an extrajudicial statement which is permissible under the court order and the rules. I don't agree with you, but I understand that's your position. So what I'm just asking you about is what you hoped to accomplish. Was it to change the media content, or was it to influence the public perception of the evidence in this case?
Objection, asked and answered.
Mr. Novak,
I don't think I asked that question. Or if I did, the answer wasn't responsive. Mr. Ballard's response to the last question was the goal was to respond to media inquiries. Was that the only goal, just to respond to media inquiries? I'm sorry.
Counsel, I need to rule on the objection before
Absolutely.
we move forward. I'm going to overrule the objection and allow that question to be answered.
The goal was to respond to the substantial undue prejudicial effect of the media stories.
What evidence do you have that there was undue prejudice? We haven't picked a jury yet.
The evidence that the reason that we were concerned about those statements is that it was producing we were concerned about the media stories that were saying, first of all, that the bullet in fact did not match, and that therefore we had no case, that we had brought a groundless prosecution. That was our concern.
Which is an issue that can be addressed through jury selection, correct?
That's one way. Yes.
It's an issue that could be addressed through an expanded jury questionnaire, correct?
Yes.
It's an issue that could be expanded through additional peremptory challenges if the court deems it appropriate, correct?
That's another way.
It's
yes.
an issue that could be addressed through individualized voir dire, correct?
Yes.
It's an issue that could be addressed under the appropriate circumstances through a change of venue, correct?
Perhaps.
A couple more questions, and then if I have any more time, I'll reserve it.
You have 28 minutes remaining.
Oh, wow.
So.
Ms. Visser scared me. Before you decided to return these phone calls, answer these emails, and accept an invitation to appear on Fox and Friends, did you ask this court to clarify its order in light of the way the media was interpreting the motion to continue?
No.
Did you reach out to anybody in Mr. Robinson's defense team and say, you know, whether you guys did this intentionally or unintentionally, the media has misinterpreted your pleading. Can we do something about that judicially,
No.
as opposed to extrajudicially?
No.
I have no further questions for Mr. Ballard.
Thank you, Mr. Novak. Mr. McBride.
Hey, Mr. Ballard, I wanted to ask you a little bit of follow-up from what defense asked you. First off, I want to ask you, did you intend to violate the court's order in this case?
No.
Do you believe you violated the court's order in this case?
No.
Did you take actions to avoid violating the court's order in this case?
Yes.
And do some of those actions include being familiar with the order,
Yes.
being familiar with Rule 3.6,
Yes.
limiting your statements to the media to those necessary to address the issues prejudicing your client?
Yes.
Did you include a statement in some of your statements that the defendant was entitled to a presumption of innocence?
Yes.
And a statement that the jury would decide the defendant's guilt as the finder of fact in this case?
Yes.
On March 30th, at about 4:43 our time, did the Daily Mail run a story entitled "Bullet Used to Kill Charlie Kirk Did Not Match the Rifle Allegedly Used by the Suspect Tyler Robinson"?
Yes.
I'm showing you on the screen. Can you see on the screen?
Yes.
Exhibit 22.
22?
Yes. Excuse me, Exhibit B.
Okay. Yes, I see Exhibit B.
And is this Exhibit B to the filing, the state's opposition to the motion to continue? What's the title of this?
I assume that. Let me see the first page.
State's opposition to the motion for an order to show cause for alleged contempt of court in this case?
Yes.
And is Exhibit B that Daily Mail story that you referred to just now?
Yes.
Was this the first story that reported, that generated all the media that has brought us to this stage in this case?
That's my understanding.
And after that story was published by the Daily Mail, are you aware of whether other outlets published similar stories?
Yes.
I'd like to turn to Exhibit C in that same pleading.
Okay.
And for the court's record, this is docket 510, Exhibit C. And this is a USA Today article, is that right?
Yes.
And the title is, "Does the Bullet Match? Key Issues Emerges in Charlie Kirk Murder Case," correct?
Correct.
And I now want to turn to Exhibit D to this pleading. And this is an article by People, is that correct?
Correct.
Also published on March 31st of 2026.
Yes.
And the title here, will you read that title?
Bullet that killed Charlie Kirk doesn't match Tyler Robinson's rifle, his lawyers claim.
Right, I now want to turn to Exhibit E to the pleading. And this is a CBS News article, also published March 31st, 2026, correct?
Yes.
And will you read the title there?
Charlie Kirk's accused assassin's lawyers question link between bullet from autopsy and rifle found near scene.
I now want to turn to Exhibit A to your pleading, or to the pleading that we've been talking about. First, updated the next day, April 1st. Will you read the headline there?
How one headline shaped the narrative way that we were relying on that was there was no grounds for us to be able to rely on that piece of evidence, that evidence didn't support our case, and because it was a key piece of evidence, that we did not have the evidence to be able to proceed in this case.
And did that make you concerned your client might be your client's
Mr.
right to?
McBride, let me stop you. There may be an issue with the audio being transmitted, so I just want to make sure that's remedied, and then we can continue once we confirm it's functioning as it should.
Thank you.
All right, do you want to?
Testing, 1, 2, 3, testing.
Mr. McBride, we can continue.
Thank you. Were these reports that we've gone over in the last couple of minutes, these news stories, were they accurately reporting what the evidence was in this case?
No.
And did that cause you concern about whether it would affect your client's right to a fair trial?
Yes, it did, because not only were those in those other articles.
When you received those calls, you testified that you and Mr. Gray had spoken about this. You'd spoken about Rule 3.6 in the court's order. But when you received those calls, you had the option, as you testified in direct examination, of just saying no comment, correct?
Right.
Would a no comment, how do you believe that response would be received by the public if the media states, we reached out to the Utah County Attorney's Office, when they were asked for comment, they responded, no comment?
Objection calls for speculation, relevance.
Mr. McBride?
The question here is whether or not Mr. Ballard responded as a reasonable attorney would under Rule 3.6C.
Could you repeat the question? I just want to make sure I'm processing it properly.
How do you believe the press would, or how do you believe the public would receive a story that had the response from the Utah County Attorney's Office as no comment?
I'm going to sustain the objection because it's asking for him to perceive what the public would perceive, and that does go to speculation.
I'll attempt to lay more foundation. Does the public's perception matter as it relates to your client's right to a fair trial?
It can, yes.
And is the public's perception ultimately what the public's, and even more particularly the potential jury pool's perception, what matters when we're talking about prejudicing your client's rights?
Yes.
And so isn't it true that you have to make a judgment about how the public is perceiving the media statements?
Leading.
This is
Well, it's
cross-examination.
cross-examination, so I'm going to overrule that objection.
Yes.
Did you believe a no comment response would cure the prejudicial effect of the media stories?
No.
Did you believe it would actually potentially increase the prejudicial effect of these stories?
Yes, especially given the kinds of stories that were circulating there, like that our case has a fundamental problem, that this is a bombshell, and for us to say no comment or to not give a response would feed my concern was that would feed this idea that the state really does not have sufficient evidence to proceed.
Okay, thank you. You mentioned before responding to these requests, you spoke with Mr. Gray about the requests and about the media that was out there at the time. Why did you speak with Mr. Gray about that?
Because we recognized that this was a significant issue and that we needed to figure out how we were going to respond to that.
And was part of that to determine whether you could ethically respond?
Yes. I think the conversation was, should we, and can we, and should we?
I want to refer you to the court's order, the pretrial publicity order, and that's published on the screen in front of you. Do you see that?
Yes.
Will you read the last sentence of that order? This is the order dated September 16th, 2025.
It says, this order does not prohibit lawyers from making statements permitted by Rule 3.6, C, Utah Rule of Professional Conduct, 3.6, sub B, sub C.
Based on the language of this order, did you believe that it prohibited you from making public statements?
No.
Did you believe it prohibited you from making public statements that were allowed by 3.6B?
No, it allowed me to do that.
And same question with regard to 3.6C. Did it prohibit you from making statements under 3.6C?
Objection, he's asking the witness for a legal conclusion.
Did you want to respond, Mr. McBride?
No. I disagree with that objection, but I think the court can rule on that without response.
Well, I'm going to overrule the objection because that was fodder for the direct examination. It was addressed. He was asked about that, and so this is cross-examination, and that door has been opened.
Okay, let's look at 3.6, Rule 3.6. And that's up on the screen in front of you. I want to go through those particular statements or particular subsections referred to by the order, 3.6B and C. There's a couple of highlights here on the screen in front of you. Is that up on the screen in front of you?
Yes, I see those.
If you look at 3.6B, will you read those two highlighted portions? That's B, basically B and B2.
Yes. It says, notwithstanding paragraph A lawyer may state information contained in a public record.
Okay. Now, before going to 3.6C, let me ask you, on direct examination, defense counsel had a line of questioning about whether you can talk about anything that's in the public record extrajudicially to the media. You began to answer that question, but you weren't given the chance to finish your answer. Under 3.6B, will you talk about your understanding of what you can talk about that is in the public record?
My understanding of that, the language of the rule is that if there is something that's contained in a public court filing, that that I can comment on that extrajudicially.
In this circumstance, was the statement that generated this in defense counsel's pleading, that the ATF was unable to tie the bullet to the gun, was that in a public pleading?
Yes.
And the report that they made that statement from, the ATF ballistics report is what I will call it, was that in a public pleading?
It was. The defense attached that report to their motion to prohibit testing, and the court had ordered that to be made public.
And that report was attached to a pleading in docket number 284. Is that your understanding?
I don't know the exact docket number, but it concerned, I think it was their January 9th motion.
Okay. And for reference, the court's order making that docket number public is docket 460, March 12, 2026. I want to go to the next subparagraph. Okay, actually, before I do, notwithstanding that this report was public by this time, the ATF ballistics report. Did you specifically comment about the ATF ballistic report and its findings in your statements to the media?
No. In fact, if you look at Exhibit 4, the highlighted portion there, I say, when I'm responding to the USA Today reporter, I say, the ethical rules prohibit, well, it says, ethical rules prohibit him from speaking publicly about forensic testing and results. And then I go on to say, but I can say generally that when you have an inconclusive result, these are the types of circumstances that might produce an inconclusive result.
Okay. Let's move to subparagraph C, 3.6C, which is up on the screen. Will you read the highlighted portion of subparagraph C?
Yeah, actually, it's not up.
It's going to take a few seconds for it to render itself on the screen. Not just yet.
I could read it from the exhibit.
Let's go ahead and do that, if you don't mind. So the first full sentence of subparagraph C.
This is from Exhibit 10. It says, notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Want me to continue?
No, that's fine. So as you read that, is there anything, do you see any language in subparagraph C that requires that any other public, undue prejudicial, substantial undue prejudicial effect of recent publicity must be generated by a defense counsel or opposing counsel?
No.
Okay, I now want to turn to your particular responses. So after you met with all these responses, or all these media inquiries were coming in, you meet with Mr. Gray and talk about whether you should and could respond. The answer is yes, we're going to respond, we should respond. Then you actually make the responses, correct?
Correct.
I'm going to turn back to the pleading that we'd referred to, where we had attached many of the news stories. We have here exhibit, let's see if this is the right one, exhibit F. And this is, I think this also appears in defense counsel's binder.
Is it the USA Today story?
This is the New York Post story. I'm going to ask you to read the first two paragraphs here on it's page. Actually, let me jump to page 46 here of the pleading. Will you read the first paragraph on page 46 of the pleading, Utah County Attorney's Office?
Yeah. Utah County Attorney's Office Prosecutor Christopher Ballard said he can't comment on forensic testing and results, but he said, quote, when the results of a bullet fragment analysis come back as inconclusive, that means only that the fragment did not contain enough detail for the examiner to determine whether the characteristics on the fragment were consistent with having been fired by a particular firearm, end quote.
And is that consistent with how you attempted to respond to all the media outlets that made inquiries?
Yes.
And is that in fact your statement?
Yes, I can't say that it's exactly word for word, but that accurately captures what I was trying to convey to the reporter.
Okay. I want to go to Exhibit G to the pleading. This is a PolitiFact article entitled, "Does a Bullet Analysis Clear Charlie Kirk Suspected Killer? What an Inconclusive Result Means." I'd ask you to read that first full paragraph, starting with when. Will you read that, please?
When the results of a bullet fragment analysis come back as, in quote, inconclusive, unquote, that does not mean that the rifle did not fire the bullet. Christopher Ballard, a spokesman for the Utah County Attorney's Office and part of the prosecution team, wrote in an email to PolitiFact.
Thank you. Again, is that accurate?
Yes.
Same answer. You can't say word for word, but in essence, it's accurate.
Right.
I want to jump to the TMZ article. And is this TMZ article here, this Exhibit I to the pleading, an article that quotes you?
Yes.
Let's go to page 58. And we talked about this quote previously. Defense counsel asked you about this. And the statement beginning with Attorney Christopher Ballard tells us, that paragraph, is that the same? Is that quote starts with generally and ends with trial? Do you know if that is, if that quote is exactly how you said it to them?
The quote, again, comes from, I'm answering two different questions from the reporter. First, the reporter asked me about these claims that the bullet didn't match. And then he asked me, so do you still have a case? Basically, do you have enough evidence to proceed? And so I was first addressing the specific question about the bullet, the claim that the bullet didn't match, and then second, I was responding to this idea that because of the forensic testing, we couldn't proceed with this case.
Okay, thank you. I'll go to the next page, 59. And I'd like to ask you to read the first two paragraphs here on page 59.
It says, as we reported, Tyler's defense team argued there's a discrepancy between the ballistic evidence and the weapon prosecutors say is connected to Robinson. In a filed motion, they wrote, quote, the defense may very well decide to offer the testimony of the ATF firearm analyst as exculpatory evidence, unquote.
And then will you read that next line as well?
Yes. It says, but Ballard says this isn't expected to derail their case against Robinson.
Thank you. Now I'll go to page 60 of the same article, the TMZ article, and ask you to read these two paragraphs as well.
It says, he told us, quote, can't speak about specific evidence, but the evidence that we detailed in the charging document is a general summary of the evidence that shows Tyler Robinson committed this crime, unquote, end quote. And it says, Ballard added, quote, he is presumed innocent. The ultimate decision will be up to the jury. We believe we will be able to overcome his presumption of innocence, end quote.
Thank you. Now, defense counsel, in one of their motions, they quoted the Standard, which is a Hong Kong agency, and did you look at that quotation to the Hong Kong or to the Standard?
Yes, when I saw that in the defense pleading.
Okay, And I've got that up on the page, on the monitor in front of you. It's page 8 of defense counsel's motion for the order to show cause. And this, there's the double indent here. Do you see that?
Yes.
Did you talk to the standard?
No, they did not contact me.
And it looks like they included some of your statements, but not all of them. Is that accurate?
It looks like they're referring to the TMZ article, and yes, they took some of the quotes, but not all of them.
Okay, thank you. If I can have just a moment. Okay, I wanted to refer you to Exhibit 4 in Defense Counsel's binder.
Okay.
Let's see, in that purple highlighted portion on the last page, the second to last paragraph, this was discussed a little bit earlier, but I wanted to make sure that this was clear. Will you tell us what you were referring to in this second to last paragraph? It reads, Ballard confirmed the ATF or FBI and ATF are adding information to the initial reports. The prosecutor expected will include data supporting the initial conclusions. Will you explain what that's referring to?
Yeah, my recollection is that the defense, is part of their motion to continue the preliminary hearing, as part of the justification for that motion, they had argued that they hadn't received all of the underlying data that supported the conclusions in the initial reports. And so the reporter was asking me about whether, had that data already been produced or whether it would be forthcoming. And I was confirming that the FBI was gathering that and would be providing that, the information that the defense requested.
Did you personally appear on Fox and Friends?
No, I did a Zoom interview that they used as part of that program.
And the video we watched earlier, is that the entirety of this portion of your interview that they used on that program?
Yes.
You didn't go to New York and sit down with them?
Nope.
Did you actually ever leave the office and go on a media speaking tour?
No, all I did was respond as the media inquiries came in.
Okay. Thank you. I have nothing else.
Thank you. Mr. Novak, redirect.
Yes, sir. Mr. Ballard, isn't it correct that there was a point in time with respect to the pleadings in this case that the defense's motion to prohibit the additional testing without some safeguards to document it, record it, monitor it, was a private filing.
Yes, the defense filed it as a private filing.
And you initially agreed, meaning you on behalf of your office, that it should be a private filing because it dealt directly with forensic examinations.
No, we opposed the motion to keep that filing private.
But as you said in Exhibits 6 and second, Your Honor. Make sure I'm citing the correct exhibit. In Exhibit 6, that you initially hoped that the dispute over the testing could be resolved between the parties, right?
Yes.
Okay. And then we filed, meaning Mr. Robinson filed, a motion to get some control over that FBI testing because the FBI had basically said, we won't let a defense ballistic expert watch and we won't videotape it, right?
I wasn't privy to what the defense was saying, or the FBI lab was saying.
But you're aware of the dispute.
There was a dispute, yes.
The FBI wanted to do further testing on bullet fragments, and we were concerned that it would have a destructive effect on the evidence. And so we asked to have a ballistics expert observe the FBI testing, correct?
I know that you filed a motion.
We asked your office to arrange with the FBI for an outside expert to observe. Aren't you aware of that?
I know that you were requesting certain procedures.
Right, was to either be present or videotape it. Or maybe you don't know what the procedures were.
That sounds correct to me. I wasn't part of those negotiations,
Okay.
that discussion.
And when the FBI didn't agree to let there be light on whatever they were going to be doing, as opposed to darkness, we filed a motion for judicial intervention, right?
Yes, you filed a motion.
And we filed it privately.
Yes.
And we argued to this court that it should be private because it addressed forensic testing not yet received into evidence and future forensic testing not yet received into evidence. And the state opposed that.
Counsel's testifying.
Didn't we file that?
Oh, counsel, there's an
I
objection.
did it again.
Would
Sorry.
you like to respond?
I can rephrase it in the form of a question.
All right, I'll go ahead and sustain the objection and maybe rephrase.
Are you familiar with the reasons why we thought the forensic testing documents and the dispute should be filed and litigated privately?
I think I generally understand why you wanted that private.
And the state decided it should be public.
We decided to oppose that motion.
It was your position that it should be public.
Yes.
And then the court overruled or denied the motion to keep it private, correct?
Yes.
And so that then became a matter of public record which you believe you could make extrajudicial statements about.
I believe the rule allowed that, yes.
Now, your testimony is that you only intended to communicate to the media generally how bullet fragment analysis works, correct?
Yes, I was responding to those inquiries and being careful to stay within the confines of Rule 3.6.
But the media inquiries were not generally how is bullet fragment analysis conducted and what are the findings and what are the conclusions. The questions were about the bullet fragment analysis in this case, correct?
Yes.
Would you agree with this following statement? In the first few weeks of this case, there were many media stories emphasizing evidence of Mr. Robinson's guilt.
Yes.
So your interpretation of Rule 3.6, because of that, is that I could go on Fox and Friends or send emails to media entities or have telephonic interviews where I say on multiple occasions, it's my opinion that my client is innocent.
Objection, relevance.
Do you wish to respond?
Mr. Ballard has testified that he doesn't think that his his extrajudicial statements violate the rule. And he specifically referred to comment 4, which says any opinion as to the guilt or innocence of a defendant or suspect in a criminal case is not prohibited because of what he says is prejudicial pretrial publicity. And so I'm asking the obverse, which is whether he agrees that that means that I or somebody I hire could go on a speaking tour. I'm not saying you went on a speaking tour, but and proclaim my opinion that Mr. Robinson is innocent without violating this court's order or without violating the rules of professional responsibility.
All right. I understand the objection and the response. I'm going to overrule the objection as it's within the nexus of what's being addressed in this hearing and what's been brought up in both direct and cross-examination.
What I understand the rule to allow is for a lawyer to make statements that the lawyer believes are necessary to protect their client from substantial undue prejudice of media stories.
So if I think in good faith that my client has been, that there is already proof of undue prejudice against Mr. Robinson because of all of the media stories, without seeking any judicial intervention, without seeking an ethics opinion from the state bar, I can schedule media interviews, I can issue press releases saying it's my opinion that he's innocent.
I think your interpretation of Rule 3.6 is up to you.
I'm asking you if you agree with that hypothetical.
Repeat the hypothetical.
Without any findings by anybody at this point of undue prejudice, and based on the media coverage to date, which we are all familiar with, do you agree, well, is it your opinion that the rule permits me to go on Fox and Friends or have telephone calls or send emails, issue a press release that says it's my opinion that Mr. Robinson is innocent, and that if I did that, I would not be in violation of this court's order or the ethical rules that we've been discussing?
I don't see anything in the rule that requires previous findings about prejudice.
It's just your conclusion that there is prejudice. That's enough?
I believe that what's required is what the rule says.
Thank you, Your Honor. Appreciate the court's time.
Thank you. Anything further for this witness?
No.
Mr. Ballard, you may step down. Thank you. All right. To defense, it looks like you have about 20 minutes left. I didn't include the cross-examination against your time. We'll go to the state's time, but how would you like to proceed next?
I have a few questions for Mr. Gray, since he was mentioned in the testimony from Mr. Ballard, and the OSC was returned against Mr. Gray as well.
Would you prefer to take a 10-minute break, or do you want to keep going? I'll defer to you.
I think a 10-minute break would be great.
All right.
Thank you.
Court will be in recess for 10 minutes. We'll come back at approximately 11:35.